Legal and Privacy Brief for March 4, 2026. California's privacy agency fine play on sports $1.1 million for forcing high school students to accept tracking technologies to view tickets they purchased. The Supreme Court heard arguments on whether geofence warrants, which compel tech companies to identify all devices in a geographic area, violate the Fourth Amendment. Federal courts in Minnesota and West Virginia issued preliminary injunctions blocking DHS from detaining refugees and immigrants without due process hearings. Here's the full breakdown of today's top legal and privacy stories. Next section, Enforcement Actions. California fines play on sports $1.1 million for CCPA violations. The California Privacy Protection Agency fine play on sports $1.1 million for requiring users to accept tracking technologies to access digital tickets they had already purchased. Play on Sports operates the Go fan ticketing platform, which is used by approximately 1,400 California schools and serves as the official platform for the state's high school sports governing body. The CPPA found that Play on violated CCPA by directing users to opt out through third-party organizations, Network Advertising Initiative and Digital Advertising Alliance, rather than providing its own opt-out mechanism, and by failing to clearly disclose its data collection practices. The practice affected high school students nationwide who were required to click Agree to tracking or forfeit access to paid tickets. Play On must implement proper opt-out methods, perform risk assessments, and comply with CCPA restrictions barring the sale or sharing of data for anyone under 13, and requiring affirmative opt-in consent for ages 13-16. Compliance action: review all digital platforms targeting minors. Implement first-party opt-out mechanisms compliant with CCPA, not third-party redirect systems. Conduct age verification for users under 16 and implement affirmative opt-in consent flows. Document risk assessments for any services processing minors' data. Source: The Record. Romanian DPA fines web application developer Euros 3,000 for security failures. Romania's Data Protection Authority fined your consulting SRL Euros 3,000, RON 14,929. 20 for violations of GDPR Articles 25, 1, and 32 after unauthorized access to personal data in March-April 2024. The breach exposed names, national identification numbers, vacation voucher details, and related dates through the company's web application. The DPA found the controller failed to implement appropriate technical and organizational measures during system design, and failed to conduct periodic security evaluations. The authority ordered your consulting to implement mechanisms for regular testing, evaluation, and assessment of security measure effectiveness to prevent similar incidents. Compliance action: if operating in EU jurisdictions, schedule quarterly security effectiveness reviews per GDPR Article 32. Document data protection by design measures at the architecture phase of any web application handling personal data. Maintain testing logs as evidence of periodic evaluation. Source: GDP Rub Anspt, Romania, -20. 2. 2026, fine against your consulting SRL. Austrian court reduces political party fine to Euros 28,000 for exposing political affiliations. The Austrian Federal Administrative Court, BVWG, partially upheld a fine against a political party for violating GDPR Article 9. 1. By exposing recipients' political opinions through an open email distribution list. The party sent campaign emails to approximately 400 recipients using the to field instead of BCC, exposing at least 100 personalized email addresses showing names. The court held that combining personalized addresses with political content disclosed special categories of personal data under Article 9, 1 GDPR, and no Article 9, 2 exception applied. The court confirmed violations of Article 5, 1, A, lawfulness, and 5, 1, C, data minimization, noting BCC would have been equally effective. Following CJU case C-807/21, the court held that fining a legal entity does not require prior identification of a specific natural person under national law. After reassessing proportionality factors including cooperation and no prior infringements, the court reduced the fine from Euros 50,700 to Euros 28,000. Compliance action. Mandate BCC for all bulk email campaigns. Train staff on GDPR Article 9 special categories, which includes political opinions inferred from campaign email recipients. Document the legal basis for all political or advocacy communications under Article 6 and confirm an Article 9(2) exception applies before sending. Source: GDPRUB. Florida woman sentenced to 22 months for trafficking Microsoft COA labels. Heidi Richards, 52, received a 22-month federal prison sentence and $50,000 fine for trafficking in Microsoft Certificate of Authenticity (COA) labels. Richards operated Trinity Software Distribution and purchased tens of thousands of genuine Microsoft COA labels from a Texas supplier between July 2018 and January 2023, paying over $5.1 million. Federal law prohibits selling COA labels separately from the licensed software and hardware they accompany. Richards directed employees to manually extract product key codes from the labels, record them in spreadsheets, and sell the keys in bulk to customers worldwide at prices below retail value. The case was prosecuted in Florida federal court. Compliance action. Ensure any resale of software licenses complies with first sale doctrine limitations and vendor licensing terms. COA labels, product keys, and authentication mechanisms cannot be separated from underlying licenses. Review supply chain for software procurement to confirm legitimate sourcing. Source: the record. Next section, litigation updates. $60.5 M. Tinder class action settlement resolves age discrimination, claims Tinder agreed to a $60.5 million settlement to resolve claims it violated California's Unruh Civil Rights Act, an unfair competition law by charging users over age 29 or over 28 after March 2, 2016, higher prices for Tinder Plus and Gold subscriptions than younger users. The settlement in Candelore v. Tinder, Inc. Case No. BC 583,162, Superior Court of California, Los Angeles County, benefits California purchasers of Tinder Plus or Gold subscriptions from March 2, 2015 onward who were charged age-based pricing. Tinder denies wrongdoing but agreed to settle. Class members who paid more will receive larger settlement shares based on amounts paid. Deadline for exclusion and objection is April 8, 2026. Final approval hearing is May 20, 2026. Class members must choose payment method or submit verification by August 18, 2026. Compliance action. Review pricing models for age-based differentiation, particularly for California users. Unruh Civil Rights Act prohibits discrimination based on age. Document business justifications for any pricing variations and consult counsel before implementing age-tiered pricing. Source: top class actions. Tesla faces class action over Model S door handles alleged to trap occupants. Plaintiff Robert L. Hyde filed a class action in U.S. District Court for the Central District of California, Case No. 3-26 CV 900 and 42 BJCMMP, alleging Tesla Model S vehicles, 2023 present, contain defective electrically actuated door handles that fail during power loss, creating a death trap during collisions or fires. The complaint alleges both interior and exterior handles require electronic latch actuation, and the rear door manual release cable is hidden beneath carpeting under rear seats, not reasonably discoverable during emergencies. Hyde alleges Tesla concealed these risks despite customer complaints and public reports, including a fatal Model Y incident where the driver died in a fire after being unable to manually open doors. Hyde purchased his Model S in February 2023 and seeks class certification, damages, and injunctive relief for fraudulent concealment, unjust enrichment, and violations of California's Consumers Legal Remedies Act and unfair competition law. Source: Top Class Actions. Unilever faces class action over Smarty Pants fiber content, claims plaintiffs Tina Marie Burials and Latanya Wright filed a class action against Canopco Inc. D/B/a Unilever in U.S. District Court for the Southern District of New York, case No. 1-25 CV 10390, alleging false advertising of Smarty Pants children's vitamins fiber content. The complaint alleges Unilever's Fiber and Veggies vitamins claim to contain fiber equivalent to 3 cups of kale, 4 prunes, or 1 cup of broccoli, while multi- and fiber vitamins claim equivalents to 2 cups of broccoli. Plaintiffs allege the vitamins contain only soluble fiber, while fruits and vegetables contain both soluble and insoluble fiber, providing different health benefits. The lawsuit seeks certification of nationwide, New York, and California subclasses for violations of state consumer protection laws and unjust enrichment. Compliance action: review all comparative health claims on product packaging, particularly for dietary supplements. Claims comparing products to whole foods must account for all relevant nutritional components, not isolated nutrients. Retain scientific substantiation for all health and nutrition claims. Source: Top Class Actions. Topps faces class action over trading card advertising plaintiff Aitan Adoni filed a class action against the Topps Company Inc. in U.S. District Court for the Southern District of Florida, case No. 0-26 CV 60187, alleging Topps falsely advertised its 2025-26 Topps NBA Chrome basketball trading card, Mega Box, as containing a chance to obtain rare blue X-Fractor cards. Topps revealed in a January 13, 2026 email that the Mega Box never contained blue X-Fractor cards. Adoni purchased a Mega Box for $84.99 plus tax from Target, believing he had a legitimate chance to obtain the exclusive cards. Topps later replaced the packaging with a new version advertising different inserts and reduced the price to $49.99. Adoni alleges breach of express warranty, negligent misrepresentation, and unjust enrichment, and seeks declaratory and injunctive relief plus compensatory, consequential, statutory, and punitive damages. Source: Top Class Actions. West Virginia court threatens contempt charges against ICE for due process violations. A West Virginia federal district court found ICE violated the due process rights of Miguel Izagüera, a Honduras native, by detaining him without a custody hearing under 8 U.S.C. Section 1226. The court rejected the government's claim that Section 1159A permits indefinite detention of refugees who have not yet adjusted to lawful permanent resident status, noting the court has jurisdiction. The petitioner is not seeking admission and faces discretionary detention under Section 1226, and no evidence supports claims that Izagüera is a danger to the community or flight risk. The court is proceeding with contempt hearings and possible fines for government officials. ICE regularly transfers detainees between states to make it difficult for them to challenge detention, as cases must be filed where the person is detained. Source: TechDirt. Next section: Regulatory Guidance. State Department directs diplomats to oppose data localization, mandates Secretary of State Marco Rubio, signed a February 18 cable ordering U.S. diplomats to lobby against data sovereignty and data localization initiatives worldwide. The cable states such laws disrupt global data flows, increase costs and cybersecurity risks, limit artificial intelligence, AI, and cloud services, and expand government control in ways that can undermine civil liberties and enable censorship. The Trump administration called for a more assertive international data policy and directed diplomats to counter unnecessarily burdensome regulations. such as data localization mandates. The directive follows the U.S. TikTok ban, which required data localization or forced sale to a domestic owner based on national security concerns about foreign data collection. European allies are implementing data sovereignty measures in response to U.S. actions, including trade disputes and weakened alliance commitments. Source: TechDirt. Western nations form 6G security coalition amid China rivalry. The United Kingdom, United States, Canada, Japan, Australia, Sweden, and Finland launched the Global Coalition on Telecoms (GCOT) at Mobile World Congress, unveiling voluntary security and resilience principles for 6G networks. The non-binding principles call for stronger cyber threat containment, data confidentiality and integrity protections, supply chain diversification, quantum-resistant cryptography support, and safeguards for AI embedded in networks. The guidance targets researchers, vendors, operators, and international standards bodies as 6G specifications develop before expected commercial deployment around 2030. The coalition does not explicitly name China, but the initiative responds to Beijing's prioritization of 6G research through state-backed initiatives, including the IMT 2030 6G Promotion Group. Chinese state-linked research claims China accounts for over 40% of global 6G patent applications. Compliance action: monitor GCOT guidance if developing telecom infrastructure or 6G-related products. Prepare for supply chain diversification requirements and quantum-resistant cryptography mandates as 6G standards formalize over the next 3-5 years. Source: The Record. Next section: Privacy developments. EFF and Google urge Supreme Court to strike down geofence warrants. The Electronic Frontier Foundation, a clue, and Google filed amicus briefs in Chatri v. United States urging the Supreme Court to rule geofence warrants unconstitutional. Geofence warrants compel companies to provide information on every device in a geographic area during a specific time period, regardless of connection to the crime under investigation. In the Chatri case, a 2019 geofence warrant compelled Google to search hundreds of millions of user accounts to identify anyone within a radius encompassing several football fields, including homes, businesses, and a church in Northern Virginia. EFF's brief argues geofence warrants are the digital version of exploratory rummaging, the Fourth Amendment, intended to prevent. Google's brief states it has objected to over 3,000 geofence warrants on constitutional grounds in recent months, including warrants that would have exposed location data for over 1,000 people inside the Islamic Center of New Mexico and users across large portions of San Francisco over 5 days. Google stopped responding to geofence warrants in July 2025 after moving location history storage on device. The Supreme Court's decision will affect other tech companies, and historic cases Google may be asked to respond to. Compliance action: review law enforcement data request policies. If your organization collects location data, prepare procedures for evaluating whether requests constitute impermissible general warrants. Document legal objections to overbroad requests that capture data of individuals with no connection to investigations. Sources: EFF. The Record. EFF urges Third Circuit to require warrants for border device searches. EFF and a clue affiliates in Pennsylvania, Delaware, and New Jersey filed an amicus brief in U.S. v. Raggio, Third Circuit, urging the court to require warrants for border searches of electronic devices. The case involves a man under investigation for illegal exports whose laptop, tablet, cell phone, and flash drive were seized and forensically searched at JFK Airport without a warrant. U.S. Customs and Border Protection conducted 55,318 device searches in fiscal year 2025, including both manual, basic, and forensic, advanced searches. Forensic searches involve connecting devices to extract and analyze data, creating detailed reports of device activities and communications. EFF argues Riley v. California's 2014 balancing test should govern, requiring warrants for device searches because travelers' privacy interests in personal data on phones and laptops outweigh government interests in warrantless access at the border. Compliance action. Advise employees traveling internationally to power off devices before reaching border checkpoints, as powered-off devices with latest security updates are more resistant to forensic extraction tools. Consider separate travel devices with minimal personal data for employees handling sensitive business information. Document policies for reporting border device seizures to legal and IT security teams. Source: EFF. LexisNexis confirms data breach affecting legacy systems. LexisNexis legal and professional confirmed hackers accessed a limited number of servers containing legacy data from prior to 2020, including customer names, user ID, business contact information, products used, customer surveys with respondent IP addresses, and support tickets. A threat actor claimed on a cybercriminal forum to have stolen 2 gigabytes of data, including millions of records, Gov email addresses, government agency and law firm account records, passwords, and IT incident tickets. LexisNexis stated the breached data did not include social security numbers, financial data, or search query information. The company engaged a cybersecurity forensic firm and reported the incident to law enforcement. Current and previous affected customers have been notified. LexisNexis Risk Solutions, a separate division, suffered a breach last year affecting over 360,000 people's contact information, social security numbers, driver's license numbers, and dates of birth. Compliance action. If you are a LexisNexis customer, review notification correspondence for details on exposed data. Assess whether exposed business contact information requires notification to affected individuals under state breach notification laws. Review vendor risk management procedures for legal research and data analytics providers. Source: The Record. Next section, policy changes. Minnesota court blocks DHS from detaining refugees under operation. Paris, a Minnesota federal district court, issued a preliminary injunction blocking DHS from arresting or detaining refugees in Minnesota solely because they have not yet adjusted to lawful permanent resident status. The ruling addresses DHS Operation Paris, post-admission refugee re-verification and integrity strengthening, implemented through memos in December 2025 and February 2026 that purported to rescind and re-rescind a 2010 ICE policy applying 8 U.S.C. Section 1159 of the Refugee Act of 1980. DHS claimed Section 1159 A permits arrest and detention of refugees with no limits on detention length starting 366 days after lawful admission, despite refugees being unable to secure lawful permanent status until after 1 year has passed. The court rejected DHS's interpretation, stating it will not allow federal authorities to use a new and erroneous statutory interpretation to terrorize refugees who immigrated to this country under the promise that they would be welcomed and allowed to live in peace, far from the persecution they fled. Source: TechDirt. Senator Wyden warns Section 230 repeal would hand Trump censorship power. Senator Ron Wyden, co-author of Section 230, published an op-ed warning that gutting Section 230 while Donald Trump is president would hand him power to rewrite rules of online speech. Wyden noted that Senator Dick Durbin, D., is co-sponsoring legislation with Lindsey Graham to repeal Section 230 entirely within 2 years. Wyden highlighted that a 2021 bill introduced by Senators Amy Klobuchar and Ben Ray Lujan to repeal Section 230 for posts the HHS Secretary decides are medical misinformation would now give HHS Secretary Robert F. Kennedy, Jr., power to silence critics of his anti-vaccine agenda. Section 230 establishes that the person who creates a post is responsible for it, enabling retweets, reshares, Reddit moderation, Wikipedia editing, and rapid information sharing online. Compliance action. Monitor Section 230 legislation. If operating user-generated content platforms, prepare for potential liability expansion if Section 230 is weakened or repealed. Document content moderation policies and procedures. Consider how changes to Section 230 would affect ability to moderate harmful content without assuming liability for all user posts. Source: TechDirt. DoD terminates Anthropic contract over AI usage restrictions. The Department of Defense terminated its $200 million contract with Anthropic and ordered military contractors to cease using Anthropic products after the company refused to provide unrestricted use of its AI technology. Anthropic specified since signing the Pentagon contract in 2025 that it would not permit its technology to be used for mass surveillance of people in the United States or fully autonomous weapons systems. In January, DoD ordered Anthropic to give unrestricted access. Anthropic refused, and DoD retaliated with termination and blacklisting. EFF stated the conflict demonstrates that privacy protections are being decided by contract negotiations between tech companies and government, two entities with spotty civil liberties records. EFF cited existing government surveillance practices, including CBP buying data from the online advertising ecosystem, ICE using tools mapping millions of devices from purchased cell phone data, and ODNI proposing a centralized data broker marketplace for intelligence agencies. Compliance action: review government contracts and AI deployment terms of service for usage restrictions on surveillance and autonomous weapons. Document acceptable use policies for AI tools. Monitor congressional action on closing the government data broker loophole, particularly bills prohibiting government purchase of personal information that failed in the Senate in 2024. Source: EFF. Next section: compliance takeaways. High school and youth-facing platforms implement first-party opt-out mechanisms for tracking technologies. CCPA requires direct opt-out tools, not third-party redirect schemes. Bar sale or sharing of data for users under 13, and require affirmative opt-in for ages 13-16. The Play on Sports $1.1 million fine demonstrates CCPA will enforce against platforms serving minors. Geofence warrant response procedures. If you collect location data, prepare to challenge overbroad geofence warrants that lack particularized suspicion and capture bystanders. Google's brief in Chattree demonstrates successful pushback against warrants covering 1,000+ people at religious centers or entire city areas over multi-day periods. Document the scope of requests and legal objections. International travel device security. Power off laptops and phones before reaching border checkpoints. CBP conducted 55,318 device searches in FY 2025, many using forensic tools that extract all data. Powered-off devices with current security patches resist extraction better than unlocked devices. Consider separate travel devices for international trips. Age-based pricing review. California's UNRRA Civil Rights Act prohibits age discrimination in pricing. The $60.5 Tinder settlement demonstrates liability exposure for charging older users higher subscription prices. Document business justifications for any pricing tiers and consult counsel before implementing age-differentiated pricing in California. GDPR security obligations for EU operations. Article 32 requires periodic testing and evaluation of security measure effectiveness. The Romanian Euros 3,000 fine and Austrian Euros 28,000 fine demonstrate DPAs will enforce against inadequate security reviews and data minimization failures. Conduct quarterly security effectiveness assessments and document data protection by design measures at the system architecture phase. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.